Good morning, everyone, and welcome to the Maricopa County Board of Adjustment meeting for Thursday, February 15th, 2024. Rosalie, would you please take attendance?
Chairman Loper,
Present.
Vice Chairperson,
Present.
Member Cardin,
Present.
Member Clapp,
Present.
Member Ward.
Present.
Chairman, we have a quorum.
Thank you very much. Move on to the announcements. This meeting has been noticed in accordance with the open meeting laws of ARS 38-431. Agendas are available within 24 hours of each meeting in the Maricopa County Planning and Development Office and are also available on the Planning and Development website 1 week prior to the hearing at www.maricopa.gov/planning. With respect to the hearing process, cases will be considered in the order they appear on the agenda unless otherwise agreed to by the board. For each case, the applicant will be given a set amount of time to present their testimony. Any witness wishing to give testimony on a particular case shall notify the board of such interest. This shall be done by filling out a speaker's card, which looks like this. And if you're here in person, Rosalie has those. Again, if you want to speak, make sure you fill one of these out prior to coming up to the podium. Or registering a desire to comment as noted on the published agenda. Also, at the appropriate time for each case, the chair will ask those attending in person and online who wish to speak to a case to raise their hand by clicking on that icon on the webinar screen. Staff will provide the chair with the names of persons who have registered and noted a desire to comment and those registered participants who have raised their hand. The chair will call on each named participant one at a time. Such testimony shall be limited to a maximum of 3 minutes. However, the amount of time allowed for testimony shall be at the discretion of the board chair. The chair will conduct the hybrid in-person and virtual public hearing according to the bylaws and according to the rules established by the chair regarding public comment. Votes will be done by roll call vote only, and the chair will verbally identify the specific members responsible for all motions and seconds. Move on to the minutes. For January 18th, 2024, any board member have any questions or comments? Any changes? All right, those are considered approved. They do not require action on our part. Next item on the agenda is code compliance review. Agenda item number 1V 2021-01864. Darren, please.
Yes, Mr. Chairman, board members, V 2021-01864 is code enforcement review for property at 35831 North 17th Avenue in District 3. The violation is construction without benefit of issued permits or clearances authorizing the work. This case was opened due to citizen complaint September 29, 2021. Concern was placement of a wireless internet tower in a residential area. Site inspection confirmed the violation and notice in order to comply, directing the respondents to obtain necessary permits was sent via USPS on October 13th, 2021. An administrative hearing was scheduled for October 26, 2023, and summons was sent via certified mail on August 7th of 2023. The hearing officer heard this case on October 26, 2023. Respondent, the property owner respondent, and the owner of the tower were present. After the hearing officer found the respondents responsible for the violation. Respondent was ordered to pay a $300 noncompliance penalty and daily noncompliance penalties of $100 if the property had not been brought into compliance by May 21st, 2024. No fine amount has been paid to date. On December 18th, 2023, respondents, through their attorney, appealed for code enforcement review with oral arguments. As a side note, I will note federal rule does place restrictions on the local jurisdiction in regard to regulating these type of facilities. However, they specifically speak to allowance in regard to regulation for public safety. An example of a public safety regulation is requirement for building construction permits. The hearing officer made a finding of fact and reached his conclusion pursuant to section 1502 of the ordinance. Pursuant to article 1504.3.2 of the ordinance, the board may either affirm the hearing officer's order of judgment or remand it back to the hearing officer due to a finding of procedural error. You're not discussing the merits of the case today, only if there was a procedural error identified. However, the board's decision today can be further appealed to the Superior Court. Staff has reviewed the case file and has found no administrative or procedural errors and recommends that you affirm the hearing officer's order of judgment. I'm glad to try and answer any questions you may have.
Thank you, Darren. Are there any questions of Darren or other staff at this time by any board member? All right, seeing none, I'll open the public hearing. Is the applicant or applicant's representative here in attendance?
Yes, sir.
Please provide your name and then go forward with your presentation.
Yes, James Carroll. I'm an attorney with Anthem Law up in Anthem, Arizona. With me is Josh Weedman. Mr. Weedman is the CEO of Tech Compass, which is the company that has this this device. We want to see if we can clear up the record. I was not involved in the initial proceeding. I got involved late. I do want to apologize. This matter was on for hearing last month. My gallbladder went. I had emergency surgery, and I appreciate the fact that you were able to carry this until today's date. I apologize for any inconvenience that may have caused to the staff or to yourselves. I started as an attorney many years ago. When I was a kid, an antenna was something that I got up on the roof and turned it when we had to get Philadelphia stations versus New York stations. A lot has changed technologically since then. I am certainly no expert on this particular kind of technology. I have talked to experts in preparation for today's hearing. Mr. Weedman is overly technological, and I think that when he tried to talk at the initial hearing on this, perhaps it kind of got lost in the weeds a little bit. But the bottom line is this is not a cell tower. This is not a radio tower. It's not a cellular tower. It is a federally protected over-the-air reception device, which is what OTARD regulates and says that local regulation cannot prohibit these devices. It's not a safety issue. In fact, the county has amended their regulations to allow these to go onto school because there's no safety issue regarding them. It's not like there's any kind of cellular waves or high voltage or anything like that. The particular regulation that was cited and that my client was found to have violated doesn't apply to this type of device. It's not that type of device. Now, my client has had extensive discussions with the staff, with the county, and I believe we even talked to the county attorney's office before I was involved. But the bottom line was most municipalities and counties and states are still in the process of drafting OTARD compliant regulations. This had to do with years ago when you had little dishes on your house, and then some HOA said, we don't like those. We're not going to allow the dishes on the house. And people said, well, wait a minute. It's the only way I can get either TV reception or cell reception. So OTARD basically said, you cannot restrict these devices and the devices, the antenna that they're located upon. What we have here is we have a high, and the reason why it's high is my client can explain, reception device that is receiving internet communication that is not available at this level locally. My client, as you would explain, is a sole internet provider to over 1,000 people in the area. He can explain some of his clients, school districts, et cetera, who depend upon his service. But what he's providing is commercially, the type of internet you'd have in a commercial facility to individual homeowners. This was required during COVID when you had some houses, you had 5 kids going to school at the same time, you had parents working at the same time, and home internet service that you would get through Cox or one of these other companies is not sufficient bandwidth in order to allow those services to operate efficiently. This is the highest quality service, and it's only available using this technology. And I could introduce Mr. Weedman, have him sworn in. He could just tell you a couple minutes about his company.
Thank you. Before the speaker leaves, does any board member have any question of him at this point? Member Person.
Thanks for your presentation. As Mr. Gerard outlined, our role in hearing this today is not whether we think it's okay to have this device or not. It's to affirm or deny the hearing officer's decision. And I'm curious because I didn't hear you say anything that talked about a procedural error at that hearing. That's the only thing that my understanding that we're allowed to be acting on. So I just want to make sure
Yes.
that was clear.
The fundamental error was this is not a radio antenna. This is not a cellular antenna. And the fine and the violation deal with antenna that this is not. And Mr. Weedman can testify as to what this is and what it is not.
And so I'll try to make this super
Just a
quick.
moment. I think the county attorney would like to state something. Go ahead, Wayne.
So you understand and to answer Vice Chairman Solom's question. Violation is building without a building permit. It's not an improper use, it's a building permit question. The argument that we don't fall under the ordinance was made to the hearing officer and rejected. They are asking you to reconsider that, and you do not have jurisdiction to do that.
May I ask you a question, sir?
Thank you for clarifying. Go ahead. I do have a couple questions, but I'll wait till after the other gentleman speaks.
You need him sworn?
There's no swearing here, at least publicly.
swearing here?
Or cursing, okay. May I ask you a question, sir? You had mentioned that the previous meeting, we were found in violation of not getting a building permit, but they're literally the definition, the legal definition on a federal level of this device is the over-the-air, and it's a federally protected over-the-air antenna reception device. That word does not, that definition, that item does not exist in your code anywhere. So how could I be in violation of not getting a building permit when a building permit doesn't exist for this? I can't even apply for one. I would be lying and saying, I have a car and I'm trying to build a house, right? Like this is not the same device. It may resemble the device in appearance to you, but legally it is not that device. So what permit should I apply for if the device is not listed in your code in either a building permit or zoning?
Could you provide your name for the record real quick?
My name is Josh Weidman.
That was directed to Wayne. Wayne, go ahead.
What is on the property is a structure. And under the state statute and our ordinance, any structure needs a building permit. If he applies for a building permit, it's up to the building officials to determine under what sections of the code they will be reviewing that. Oh, I'm sorry, I
Yeah.
forgot.
They can't hear you online.
I'm so soft-spoken, I always forget. I'm sorry.
We usually can hear you clearly.
Online doesn't pick it up. Under state statute and our ordinance, a structure is required to have a building permit. There is a structure on the property. What category or classification that structure falls into is for the building official to decide. If an application had been filed for a building permit, a response would have been given. If they were dissatisfied with the response, there is a procedure to appeal that to a hearing officer. That's not what's in front of you. What's in front of you is the fact that the hearing officer found there is a structure on the property that does not have a building permit. That's the only thing that was found, and that's the only thing that's before you today. And whether or not in reaching that decision, there was some procedural error that occurred.
Thank you. Yes, go ahead. You have
Yeah.
2 minutes between the two of you
I can
to.
cut to the chase. If we could remand this back to the county planning department, apply for a permit for the foundation, which would be for the structure. The problem we had is it's not what the tower, for example, if you put a cell tower, their setback requirements, they don't apply to this device. So perhaps now that I'm involved and we do have experts involved, we can go back to the county planning officer. And my client is willing to apply for a foundation permit if need be. I understand the county council's point that you're putting up a structure, obviously where it's located, what it is, et cetera, is of a concern, legitimate concern. My client is willing to apply for that permit, but the issue had to be, it's not for a radio tower, which is what he was cited for.
And the only thing I'd like to,
I'll get 2 minutes, 1 minute.
so the only thing I'd like to add to this is in the beginning, you mentioned that there is regulation that prevents overregulation of these devices to receive internet to the homeowner. And this is not possible without this device. And you mentioned that you cannot regulate due to safety. My company has installed these at schools. I worked with ASU and NAU on the Connect the Unconnected projects. Maricopa County actually gave $25 million to ASU for that project, and it's still in continuance today. And we literally put these on schools. No permit required because the county has waived that for any property that is owned by the county. So schools, AZ Game and Fish, all of it. We could do these, and I've personally done them. So you can't claim that it's due to safety if I can install them at a school And I can install them at my property right next to the
Yeah.
school.
Schools and like government offices, they're exempt. There's a difference. Then I don't believe the county waved a wand to say you don't have to do it. They're just simply exempt.
But they wouldn't be
Federal
exempt.
facilities as well. They can do courtesy plan review and courtesy inspections, but there's not a requirement. Is that correct?
Mr. Chairman, you are correct. Under state statute, school districts do not have to meet building codes. They can if they choose to. And just to understand, you do not have the jurisdiction to remand this to the department. You only have jurisdiction to remand it to the hearing officer because you found a procedural error. However, if I understood Mr. Gerard's presentation, which I think I did, there are no penalties accruing until May of this year. So the applicant has been free and still is free to come in and get a building permit, and that will be the end of it.
Thank you for clarifying that because I was going to have a question on that. I have a question for the applicant. Again, we're not to decide the merits of the case, but I do find this somewhat fascinating. Do you have electrical power to it?
It's all low voltage, sir. So it's low voltage. It
Solar?
uses, no, like 48 volts. So we convert it to 48 volts. And so it's basically like home routers in your house with a big antenna.
I was more curious if you got a permit for electrical for it, which would have counted. I was just curious if it was hooked to the grid, hooked, to.
No, it's just tapped into the existing homeowners and we convert it to 48 volts. So
Okay.
nothing special, nothing high power.
Any other questions of the applicant by any member Clapp?
I'm having a little trouble with the concept of now applying for a construction permit when you've probably been asked by the department to apply for a construction permit. And my report says that you or the respondent said they would apply for a permit back in early 2023. So that's a year ago. So now to tell us that you're going to apply for a construction permit seems kind of like a little too late, in my opinion. And as was stated, even if we agree with the hearing officer today, you can apply for a permit. That's all the county is asking you to do.
We just don't know what permit to apply for, ma'am.
Well, I'm sure they can tell you that.
It doesn't exist. That's the problem.
I don't know if it doesn't exist, but my opinion would be that there is a permit needed to do building of a tower.
The county is aware, and I believe you're a part of this, Wayne. Wayne, I don't know if it's rude to call you by your first name. They are familiar with the fact that this is missing, and they're under the process of rewriting the code. It's going to take them 2 years. So in the midterm, they're asking us to say permit it as something, and we're making stuff up at this point in that 2-year gap. So that's where we've been confused on what to apply for.
Mr. Gerard, could you reply to that and let me know is there a permit available for them to apply for?
Yes. There is a commercial construction permit for a tower structure that is available. I sent it to the applicant's council the other day. If there's a question as to whether or not there should be a residential permit, we can discuss that with the building official. But we're asking for a building permit for this tower support structure and any electrical connection. In regard to updating our zoning ordinance, it has nothing to do with this issue. There's nothing pending right now other than over the years, we've routinely asked people in the wireless communication and information internet technology services to provide us with red lines to our existing ordinance, because there's things like the maximum 8-foot, this isn't related to this case, but the maximum 8-foot antenna radius, the maximum 30-inch support structure diameter. Those things apparently they have issues with. There's been questions about a 2-to-1 setback requirement rather than a 1-to-1 setback requirement. So I've never gotten any red lines back from any of the industry folks. But in regard to the ongoing review of the zoning ordinance, that's just an overhaul, a review of the entire ordinance. It has nothing specific to this section.
Chairman, if I could just state for the record, that's part of the issue. It's not commercial service. This is residential service. And as the gentleman just stated, there is no applicable permit for residential service. There is for commercial, and what they're saying is you have to apply for commercial. My client's saying, well, it's not commercial service. Am I submitting fraudulently for a permit that is not for the service that's being provided to the homeowner?
So again, I kind of want to follow that up. So I'm going to ask a question, but really we're out in the weeds at this point. So the tower it supplies internet for one person and you don't receive any monies for that.
So it is the original structure is built for the homeowner to receive internet. By OTARD, this is covered both. So the reception is covered, turning this into an OTARD device. Once that customer has established service, we then can do distribution from that. But the primary function of this device is for the reception for the property owner. And it is absolutely wrote out in OTARDs very specifically that it's covered, what's covered, the limitations that can and cannot be put on these types of devices, as well as the number of dishes, et cetera. That is not something that could be regulated anymore. And they did this because just so you guys know, there's hundreds of these in Maricopa County serving tens of thousands of people. I had a disgruntled employee and a competitor turn in every one of my sites. So we have actually 5 more of these cases open. Meanwhile, Maricopa County is on site at my tower. I showed them 7 others that are not permitted. And their answer is we don't care. These are the ones that reported. Literally it's over 10,000 customers are served via these towers.
So you say there's hundreds of towers and tens of thousands of subscribers. So is the tower just serve that property?
So it serves that property, but it also serves the surrounding area. So but we cannot legally, by OTARD standards, I cannot put up a commercial tower on somebody's property just to serve the community and not serve that homeowner. So
Understood, but that sounds commercial to me. Anyway, I don't want to get too far in the weeds. Anything else before we see if there's other comments?
Yes, that it is broadband service for the record. This OTARD does deal with broadband service, and just to put in the record, this is broadband service.
Understood. Thank you. This is your James Carroll. This is your card. As we've spoken, I don't have any other speaker request cards. You guys go ahead and have a seat. We may have more questions for you. Is there anyone in the audience who wishes to speak on this item? Do we have anyone online?
No one online has indicated a desire to speak.
Okay. I'm going to go ahead and close the public hearing and turn it over to the board for discussion and or a motion. This is in District 3. Member Person.
And despite generally wanting to help move things forward, our scope and obligation here is limited to what I said earlier. So, I would encourage the applicant to continue to work with staff. And if staff is saying this permit will do the trick, I would encourage you to continue working towards that. But I would move that we affirm the hearing officer's order of judgment for case 2021-014.
We have a motion for confirmation or upholding the compliance officer decision from Member Person. We have a second by Member Clapp. Roll call vote.
Member Carden,
Yes.
Member Clapp,
Yes.
Member Ward,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, the board has affirmed the hearing officer's determination by a vote of 5-0.
Thank you very much. I wish you the best of luck in speaking with staff. Thank you. All right. Move on to agenda item number 2, which also is under code compliance review, V 2023-01193. This is in District 2 for Harry and Alice Hazley. Darren?
Mr. Chairman, board members, this is code enforcement review regarding a violation of the accumulation of junk trash debris and dead, dried, uncultivated vegetation or weeds for property at 8813 East Avalon Street in District 2. Case was opened due to citizen complaints, plural, on June 6, 2023. It was verified by site inspection. Notice in order to comply was sent to the respondent via USPS, ordering them to bring the property into compliance by July 27, 2023. Follow-up inspection on that date found the site to remain non-compliant. Administrative hearing was scheduled for October 12, 2023. A summons was sent via USPS certified mail and posted on the property as of August 30th, 2023. Case was heard by the hearing officer on October 12th. The respondent failed to appear. After that hearing, the hearing officer found the respondent responsible, ordered him to come to compliance and to pay a $250 noncompliance penalty and daily noncompliance penalties of $25. No fine amount has been paid to date. The site remains in the same noncompliant condition. Respondent appealed for code enforcement review with oral arguments via USPS. He argues that he is disabled, has financial issues that prevent him from addressing the issue in a timely manner. Staff notes that's not a procedural error and is further not denial of responsibility for the violation. The hearing officer made a finding of fact and reached his conclusion pursuant to section 1502 of the ordinance. And pursuant to section 1504.3.2 of the ordinance, the board may either affirm hearing officer's judgment or remand it back to the hearing officer due to procedural error. Staff's reviewed the record, finds no errors, recommends that you affirm the hearing officer's order. The respondent did not appear last month. It was continued this month. Staff mailed the report to the address of the property owner of record, as well as posted the entire report for today on site approximately 3 weeks ago. And the officer at the time spoke to an individual on site and reminded him of this hearing. I do not know if the respondent is present today.
Thank you. Any questions of Darren or staff at this time? I do have one. And Darren, if you said this, I apologize, I didn't catch it. Did they enter into a compliance agreement?
No, they have not entered into compliance.
Okay, thank you. Go ahead and open the public hearing. Is the applicant or applicant's representative in attendance, Harry or Alice Hazley? I don't have a speaker request card from them. I don't see anybody raising their hand or acknowledging they're that person. Do we have anyone online?
There's no one online indicating a desire to speak.
All right. If no one's here to speak on this, the applicant's not here. Our bylaws talk about that we do a continuance. That already occurred last month. So we can take action if we see fit.
Mr. Chairman, members of the board, this is not an application, this is an appeal. So I don't believe that bylaw provision would apply. The board, as a courtesy, last month agreed to continue it, but it's not unusual as an analogy for a case to be appealed to the Court of Appeals and the judges deciding they don't need any further presentation and deciding it on the papers. So you would certainly be free to do that as well.
Okay, thank you. No applicant or applicant representative. Is there anyone here in attendance who wishes to speak on this item? No one's raising their hand. Do we have anybody online?
There's no one online.
No one online. Okay, I'm gonna go ahead and close the public hearing and turn it over to the board for discussion and or a motion. This is in District 2. Member Clapp?
I'm glad we were able to continue this in hope that we could hear from the respondent about the situation at their property. And I certainly have sympathy for the dilemma that the respondent described in a letter to the county about the reasons why the trash and junk and debris and everything has not been cleared away. But I also have sympathy for the neighbors that have to put up with what's in their neighborhood. Looking at the pictures, the accumulation there is very disturbing. And I also believe that any person that works with the fire department would say that this is a fire hazard. How did you get a fire truck to this home? Have a hard time doing it with all the debris in the yard. So my feeling is something needs to be done. I'm not sure what that will be. Maybe there is some civil service agency that can step in and help these people. But nevertheless, I would make a motion to affirm the hearing officer's order of judgment on this case.
Thank you. We have a,
Case number 2023.
thank you. We have a motion to affirm the hearing officer from member Clapp. Is there a second? Member Person beat you both, just barely. We have a second by member Person. Rosalie, would you please take roll call?
Member Carter,
Yes.
member Clapp,
Yes.
member Ward,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, the board has affirmed the hearing officer's determination by a vote of 5-0.
Thank you very much, Rosalie. Move on to our regular agenda. Item number 3 is BA 2023-058, identified as the Rexine property. Hopefully I'm saying that correctly, in District 3. Adam?
Thank you, Chairman and members of the board. Adam Cannon, Planning and Development. Case BA 2023-058 is for the Rexine property in Supervisor District 3. Next slide, please. The site is located at 46769 North 35th Avenue in the New River area in the Rural 43 zoning district and is approximately 1.25 acres. Next slide, please. The request includes the following: a proposed hillside disturbance outside the lot's principal building envelope where it's prohibited, and then a proposed septic encroachment outside the lot's principal building envelope where it's prohibited. These requests would allow for a new single-family residential property to be developed. There is one area resident who is opposed and sent correspondence concerned that the hardship associated with the site is self-created by the new owner. In staff's findings, we do find that a native wash appears to be a peculiar physical condition of the land with regard to the zoning district. It is located in the center of the property and restricts the practical building envelope to a small area, which is pushed towards the front or the south end of the property. The site is also nearly 70% hillside, and hillside regulations within the ordinance require that all disturbance related to development occur within the principal building envelope. In this case, it appears that applying the hillside regulations on the site appears to present an unnecessary hardship with respect to the zoning ordinance due to the limited building area remaining on the site. The lot itself, a prior owner split the current lot via unregulated land division from its parent lot, along with 3 other lots that met the zoning district requirements for lot area and lot width. To staff, there does not appear to be an alternative configuration of those legally permissible lot splits, such that the native wash would not be present and creating a hardship for one of the properties included in the split. So broadly, it appears that the peculiar condition of the property is not self-imposed in the line of title. Lastly, the applicant's site plan is proposing a modestly sized home, and it does not appear to be an attempt to use the variance process to allow for a substantially large home that does not meet ordinance requirement due to its size and the owner's choices. Additionally, staff notes that the primary structure is fully located within the principal building envelope. If the board finds that the applicant has a proven entitlement to the variance, staff would offer the board the following conditions of approval. Condition A would be that the variance approval permits a hillside disturbance outside the lot's principal building envelope of up to 7,300 square feet. And the second is that variance approval permits a septic encroachment outside the lot's principal building envelope in accordance with the hillside disturbance condition of 7,300 square feet. Thank you, and if there's any questions, I'd be happy to answer.
Thank you, Adam. Great presentation.
Mr.
Are there
Chairman?
any questions of staff
Mr.
at this
Chairman,
time?
real
Yes.
quickly, I'm sorry to interrupt. Just to clarify, we often refer to conditions out of habit, but these are just numbered items that are memorializing a variance approval should you choose to act. They're not conditions.
Okay. Understood. Thank you for that clarification. Any questions at this time of Member Person?
Thank you, Adam. So since staff's supporting this, the reason this is before the board is because of this one letter. Okay, thank you.
Any other questions? All right, I'm gonna go ahead and open the public hearing. Is the applicant or applicant's representative here in attendance? Come on up and provide your name for the record and then go forward with your presentation.
For the board, I do have the colored copies if you guys would like to review the presentation physically.
Yeah, we're probably okay because we all have screens and
Okay.
stuff. So
Thank you.
No trouble.
we need some detail. We could certainly get it.
Well, good morning, and thank you for your attention. My name is Joshua Lee. I am the applicant for the variance case BA 202-3058 on behalf of Tia and Matt Racine, the property owners. And as you guys have already read off the staff's notes, I apologize for any doubling of the comments made, but I would like to quickly review the requirements to which I'm obliged to prove that the variances requested meet. And to these requirements, I paraphrase: that the site presents an uncommon peculiar physical condition that is not self-imposed in the line of the title, and which peculiar conditions create hardship to reasonable development. Further, that if the variance is granted, it will preserve the general intent and purpose of the zoning ordinance. Next slide of the staff's observations, and briefly to those requirements. When the staff had reviewed the context of the site, and I summarized from their observations, they had found the wash, which runs in the middle of the site from east to west, has a direct impact on the possibility of a practical building envelope. This element, coupled with some 70% of the site's area identified as hillside slopes, their combined effect on a practical building envelope is cumbersome. When the staff had found that applying the hillside regulations, given this context, does present an unnecessary hardship due to the limited area for the practical home. They also recognize that in lot splitting by a previous owner, the wash was granted this particular lot in the split, and so the hardship identified was not self-imposed. Now, our request for variance in conflict with Maricopa County Zoning Ordinance Article 1201.6.1 and Article 1201.6.12 stem from an inherent desire to create a modest-sized home for a young family with ambitions to enjoy and appreciate the natural beauty of the area within and surrounding their property. The intent of the home's design is not to overcome and impose on this beauty, to which I appreciate and agree with the zoning ordinance that I understand was implemented in order to maintain and protect the environment for the residents and the greater community who visit. With respect to the environment and the zoning ordinance, the design of this residence was not meant to obstruct the natural features like the wash that runs east to west in the middle of the site, but reacts as to protect it in place. The requested disturbance of the hillside outside the lot's buildable envelope is driven by the square footage necessary for utility, the subterranean or otherwise hidden equipment for the septic system. Our reconciliation for the disturbance is in the final condition of the area requested for the variances. That condition is a fully revegetated and restored lower Sonoran desert plant palette, as is its current condition, with the intent of rehomogenizing the proposed disturbed area to its natural state and not imposing any physically visible violations to the hillside disturbance ordinance. I earnestly request you to consider granting approval for these variance requests in the spirit that the variances are reasonable and fair to maintain the general intent and purposes of the hillside zoning ordinance, of which is not limited to, but as it pertains to this case, is to maintain the land's inherent beauty for Maricopa County residents. Thank you.
Thank you. Really good presentation. Are there any questions of the applicant by any board member? Member Person?
Thank you. I was just wondering if you've had any conversations with the person that submitted the letter of opposition.
I had not directly reviewed the letter of opposition in the
Okay.
staff's notes or otherwise in the green checklist that was granted from Adam.
Okay.
Mr. Cannon.
Thank you. I just was curious.
Okay.
Any other questions of the applicant at this time? All right, if you please have a seat and may call you back up for additional questions or comments.
Thank you.
So this is a public hearing. I don't have any speaker request cards for this case. Is there anyone in the audience who wishes to speak on this matter? Yes, sir. If you could come up and give your name and then go ahead with your presentation.
Morning. My name is Matt Ringy. I actually live next door. I don't have a speaker card, but if I need to fill one out, I can definitely do so.
It'd be nice afterwards is fine.
Okay. So I do own the home that is just to the west of this property. My only question is in relevance to where is the septic system going to be put in? Because on the, and that is my home right there. So the septic system there, so and the leach field would be near on the end of my property, which washes down into the wash. Now, I don't know who sent in the letter to the board, but I can definitely see why they would have, because where the septic system is being, requested to be put in, it does flow right into the natural wash that is on the property.
Thank you. Could you go back to the slide that showed it was a site plan with the wash and the septic? There we go. Oop. That particular one. So to me, it would seem you can clearly see the wash in the home, obviously, that the only area left on that particular side of the wash is the area where the septic is indicated to be placed. A question for staff. Septic systems are a below ground discharge after some type of treatment. They're not an above ground that would flow into a wash, are they?
I'm comfortable in saying almost never would that latter be the case, but they are disturbance.
Correct. I understand that. And that was my understanding too, that they don't. So
I guess my question would be where is the leach field in relevance to where my home and the wash is, considering that my home is significantly lower than this property?
based on this, and north is to the right, to the right. It looks like the septic leach field is that it looks like a series of tubes or a windy S.
Correct.
So it's adjacent to the property, or not adjacent, but it's close to the property line. It looks like it's about midpoint. If they're all rectangular, you could kind of judge from there. To the north of that is a reserve area. So all septic tanks have to have a reserve area in case there's some kind of failure. What I could tell you, because it looks like you're downstream, is that they're designed to not provide any discharge into a wash. It's supposed to percolate, that they're designed for percolation. But they're Maricopa County Environmental Services Department is a regulatory agency. I'd encourage you to get a hold of them, and Adam or Darren or somebody might be able to give you contact info. Talk to them about that. Find out, hey, I'm seeing what clearly is, it's not happening off site to them, it's happening at their site and going on my property. There are remedies to that. I don't know what those are, but I would encourage you to get that information, or at least the contact information from staff if you could.
Mr. Chairman, just
Yes.
to add, and I know that's not part of this request directly today, but Environmental Services has regulations for location of septic systems. They got to be certain distances from any water feature, any drainage way, any tree, any building, any impervious surface such as a driveway or a road, and certain distances from potable water wells and lot lines. There may be allowances for deviation based upon engineering or with alternative systems that have engineering requirements. We're all reviewed as part of the septic tank permit from Maricopa County Environmental Services Department.
Thank you very much. Anything else to add at this time? All right, thank you.
Thank you.
Appreciate your time. Is there anyone else in the audience who wishes to speak on this matter? All right, seeing none, is there anyone online?
There's no one online, Chairman.
All right, I'm going to go ahead and close the public hearing. Excuse me, as I mentioned, it's in District 3. I'll turn it over to the board for discussion and or a motion.
I feel there is a peculiar condition, and I would support staff's recommendation and move that we approve case BA 2023-058, subject to the language in the staff report.
Thank you. We have a motion for approval by member Person. Is there a second? Second by member Cardin. Rosalie, if you would please take roll call, and you can only count Fern once, even though she's here twice on the screen.
Member Cardin,
Yes.
member Clapp,
Yes.
member Ward,
Fern,
member Ward,
can you hear us?
you can't.
Fern, can you hear us?
Aaron need to call.
Martine, is she? Okay. Okay, she said yes. Yep, she's nodding yes.
Okay, she's nodding yes. Thank you. Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, we have a motion for an approval by a vote of 5-0.
Thank you and congratulations. I encourage you to reach out to your neighbor. Where'd the applicant go? Have, I know you're the contractor, but between you and the homeowner, talk to your neighbors, become friends with them. It's always helpful. Right. Move on to the next item, which is regular agenda item number 4, BA 2023-062, the Sanchez property in District 5. Nick?
Thank you, Chairman Loper, members of the board. Case BA 2023-062 is a request to establish an 11-foot south setback on the Sanchez property where 40 feet is the minimum required. Next slide, please. So the property is located at 3316 South 196th Drive near the southwest corner of Jackrabbit Trail and Lower Buckeye Road in the Buckeye area. This is a rural 43 property on which the owners are proposing to build a detached garage to the south of the existing single-family residence. Next slide, please. So the property is bounded to the east by an ingress-egress easement for 196th Drive. Originally, this made the east the front of the property, as the east was originally the only side with legal access. However, during the review of the building permit for the residence, the owner recorded an additional 20-foot wide access easement extending 60 feet along the south lot line. This additional easement established the south as the front, the north as the rear, the east as the street side, and the west as the interior side. This allowed the residence to be built 30 feet from the west lot line, 30 feet from 196th Drive, and about 40 feet from the south lot line. However, the owner is now proposing to build a detached garage within the south setback, and as the MCZO does not allow detached accessory structures within a front yard setback, the applicant is requesting this variance. Staff notes that although the easement along the south lot line was recorded as an access easement, it does not appear to be used as such. The southern portion of the property is screened and landscaped as though no such easement exists, and there appears to be no other beneficiary to the rights bestowed by this easement. It appears it was only recorded for the purpose of establishing setback lines favorable to the then proposed layout of the residence rather than for any practical access concerns. Regardless of the easement, the layout of the site reveals there are alternatives available to the owner for building the garage without variance. Nearly the entire north half of the property is undeveloped. The garage could be located north of the residence without encroaching into either the north or the west setback. Even if the garage did encroach into the north or west setback, the MCZO allows detached structures within a required rear or interior side yard to the extent that they do not occupy more than 30% of either yard and do not come within 3 feet of any lot line. Next slide, please. If the board finds that the applicant has satisfied the statutory test and has stated its findings on the record, the grant of this variance will memorialize the following. Item A, variance approval establishes an 11-foot south setback line for APN 502-47-008W. At this time, I'd be happy to answer any questions.
Thank you, Nick. Good presentation. Any questions of staff at this time? Member Person.
Nick, this image on the screen is north up.
Member Person, that is correct.
Thank you.
I do have one question. So you mentioned the easement it's not serving a function, but it's an easement. So because it's the narrow part of the property, the south becomes the front. if that easement didn't exist, is the south still the front?
Chairman Loper, from what I understand, during the review of the building permit for the original single-family residence, the only access to the site, the only easement serving access to the site was 196th Street on the east side. So even though the north and south are the narrower lot lines, because of that fact, originally the east was in fact the front. And from what I understand from review of the building permit, from records of the original building permit for the home, the applicant proposed the residence be set back 30 feet from the east and the west. However, the regulations at the time would have required 40 feet. And so one of the suggestions by the zoning plan reviewer at the time was to record a new access easement along the south lot line. And that is what made the south the front. And so that's how we got to this point now where the applicant is proposing that detached garage in the south. And because the south is now the front, it could not be built there without variance.
Thank you. Thank you. I appreciate that. If that easement were to go away, and I don't know if it can or not, I'm not a title person, would this request still require a variance?
So if the easement were to be, I'm not sure what the process is for removing an easement, but if the easement were to be removed, yes, the east would return to becoming the front. And because the south would become the side, the detached garage could be built there. However, the residence as existing would now be encroaching 10 feet into the required rear yard.
Okay,
So there wouldn't need to be another variance for that request.
just the other side of the
Correct.
house. All right, thank you. Any other questions of Nick or Darren or anyone else at this time? All right, open the public hearing. Is the applicant or applicant representative in attendance? From Keo Engineering, David Gonzalez. I don't have a speaker request card for anybody, and I don't see anybody raising their hand. Do we have anybody online who wishes to speak on this item? We do? Okay. If that person could please provide their name and then go forward with your presentation, please.
David is unmuted. He should be able to speak.
Okay, can you hear me?
Yes.
Okay, sorry about that. So I'm David Gonzalez. I'm the representative or agent, shall we say, for my client, Mr. Lopez. Pretty much what we're imposing is trying to get that proposed detached garage on that south, what we would say the south portion of the house, mainly because of the entrance of the garage to keep it pretty relevant, which would, be more common and accessible for our client to be able to drive in. I do know on the north side of his property, yes, there is room to do that. But again, we have septic in place on the north side. And also on that north side would be more of a attendance feature for, family events or just, family use. So that's why my client is proposing that detached RV garage on the south side, again, to keep it kind of more close to the home, commonly for the garage, and just more of a favorable entrance for the home. But again, we're here because of the easement and that setback issue, which is, a little unrare, but again, we're here.
Thank you. Any questions by any of the board members of the applicant? All right, seeing none, hold tight. May have more questions for you. Is there anyone in the audience who wishes to speak on this item? Seeing none, do we have anyone else online?
There's no one else online.
Oh, thank you. I'm going to go ahead and close the public hearing. Turn this over to the board for discussion and or a motion. This is in District 5.
Mr. Chairman, at this point, I would like to move that we approve the requested variance establishing an 11-foot south setback line for APN 502-47-008W.
Thank you. We have a motion for approval by Member Ward. Is there a second? We have a second by Member Person. Rosalie, if you please take roll call.
Member Carden,
Yes.
Member Clapp,
Yes.
Member Ward,
Yes.
Vice Chairperson,
Yes.
Chairman Loper,
Yes.
Chairman, we have a motion for an approval by a vote of 5-0.
Thank you and congratulations to the applicant. Move on to the next item on our agenda, item number 5, BA 2023-063. It's in District 4 for Our Lady of Lourdes Roman Catholic Parish Son. You don't want to screw up church names. I know. Is it Lourdes? Lourdes? Lourdes. Tell I'm
Chairman.
not Catholic. Nick, turn this over to you. Before you get too far into the presentation, we did receive this from you or from Darren. Does that have any bearing as to whether or not we have to discuss this variance or still variance is needed? It's just not a site visibility issue. Okay, go ahead. Sorry about that.
Thank you, Chairman Loper. Case BA 2023-063 is a request to establish that a sign may be located 0 feet from the west property line for the Our Lady of Lourdes Roman Catholic Parish Son, where 20 feet is the minimum required. Next slide, please. So the property is located at 19002 North 128th Avenue in Sun City West. Next slide, please. So this is an R17 property which forms Tract D of the Sun City West Unit 12 subdivision, which was platted in 1978. Construction on the church began shortly thereafter. This variance request concerns a new monument sign. Per Article 1402.5.1 of the MCZO, a freestanding sign identifying a church may be located within a required yard, but not closer than 20 feet to a property line. The applicant is requesting a variance to allow the sign to be located abutting the west property line. Next slide, please. So an existing sign, as can be seen in one of the pictures shown, is located at the northwest corner of the property facing 128th Avenue and meets the 20-foot setback requirement. The new sign, the proposed sign, would replace the current one, although it would not be located in the same location. Rather, the new sign would be located about midway along the west lot line, and the picture on the top left shows where it would be located. Next slide, please. So this excerpt from the site plan also shows where the sign would be located, as well as the elevations. The reasoning provided for the variance request was to maximize the sign's visibility from the road, as well as to establish some distance between the sign and the church. The church does come closest to the lot line at about the point where the sign would be placed, but even there, however, the church comes no closer to the lot line than 55 feet. If the sign were relocated 20 feet to the east to meet the setback requirement, there would remain ample room between the sign and the church. The sign would measure about 14 feet long, so placing it 20 feet from the lot line would place it just over 20 feet from the church. Not only is there ample space to place the new sign without need for variance, but the lack of visual obstruction such as trees or walls within the west setback suggests that moving the sign to meet the 20-foot setback would not substantially reduce its visibility to drivers or pedestrians. Staff notes that the Planning Engineering Division had expressed concerns during its review that the sign might not meet site visibility standards. However, the applicant has since provided a revised site plan featuring a site visibility analysis per the handout memo provided. The Engineering Division now has no objections following confirmation that the sign would not conflict with site visibility. If the board finds that the applicant has satisfied the statutory test and has stated its findings on the record, the grant of this variance will memorialize the following. Item A, variance approval establishes that a sign may be located 0 feet from the west lot line for APN 232-05-818. At this time, I'd be happy to answer questions.
Thank you, Nick. Another great presentation. Are there any questions of staff at this time by any board member? All right, seeing none, I'm going to open the public hearing and ask if the applicant or applicant's representative is in attendance. Please come up and give us your name for the record and proceed with your presentation.
Morning. My name is Charlie Gibson. I'm representing the applicant. I've had the luxury of talking to this board for about 15 years. The reason that we're requesting a variance is the site, as stated by staff, was created in the 1970s. At such time, a setback for signage did not exist. When the code was rewritten about 15 years ago, working with staff at the very beginning of that period, staff acknowledged that a 20-foot setback for signage really wasn't the intent of the way the code was written. but that is how it reads. So over the course of those last 12 to 15 years, we have come in front of the board and requested that we move the signs closer to the street. Its primary purpose is that as it is meant for vehicular traffic to see, when you set it far away from the road, it almost creates a safety issue because people are taking their eyes off of the road to look and see what the sign says. Nick, were you able to get the exhibit that I sent you?
I believe it should be in the presentation.
Okay, if we could go to, okay, perfect. What you're looking at in front of you is a list of just the cases that my company has presented to the board over that period of time with the same request, and all of them have been approved. Just to show that there's not a precedent that would be created. In fact, if we were denied, that would be a new precedent. And as I said, I've been working with staff for a long period of time. When the code is rewritten, this may be addressed, but at this time, we've had to go through the variance process at staff suggestion to get that setback changed and allow us to put the signs closer to the street. And with that, I'll answer any questions that you have.
Thank you very much. Are there any questions by any of the board members of the applicant? Seeing none, hold tight. May have more for you. This is a public hearing. Is there anyone in the audience who wishes to speak on this item? See no one. Do we have anyone online?
There's no one online.
No one? All right, I'm going to go ahead and close the public hearing and turn it back to the board for discussion and or a motion. This is in District 4, which I represent. I'd appreciate someone else making the motion. I will say that it's a beautiful sign. I've always found it kind of humorous. Maricopa County is not alone, that signs have to meet a setback, which kind of takes away from the purpose of the sign. Nonetheless, I didn't really agree with McDodd initially about the site visibility issues. It's on the outside of a curve, albeit a very slight curve. But now that's not even an issue, and I personally am in favor of it. Turn it over to somebody else to do me a solid. Member Cardin.
I move that we approve BA 2023063.
We have a motion for approval by Member Cardin. Do we have a second? Second by Member Clapp. That close, Fern. Rosalie, if you please take roll call.
Member Cardin,
Yes.
Member Clapp,
Yes.
Member Ward,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, that's a motion for an approval by a vote of 5-0.
Congratulations. Move on to the next and final item on our agenda. Number 6, under the regular agenda, BA 2024-003, the Gill Living Trust property variance in District 2. And this is going for Joel. Joel, go ahead.
Thank you, Chairman Loper, members of the board. Agenda item number 6 is for case BA 2024-003, variance for the Gill Living Trust property. Site is located in Mesa at 77th Place in McKells Road in District 2. Next slide. This variance to allow for a 9-foot side setback where 20 is required in the R135 zoning district, in addition to memorializing a legally non-conforming lot width. The prior home on the site suffered a fire in June of 2023 that required a full demolition. The applicant is proposing to rebuild the home in the same location to connect to the existing hookups on the property. Next slide. The existing home was built in the 1980s, and the site itself was subject to a down zone from R118 to R135 in what was anticipated to be an annexation into Mesa. Zoning ordinance regulations require new developments on lots that contain non-conforming conditions to come into compliance with the current standards. This came into effect once the home was demolished after the fire. Next slide. Staff would offer the following conclusions. There do not appear to be any peculiar conditions that present undue hardships when redeveloping the property. The home can be rebuilt to meet the current setback requirements. With that, I'm happy to answer your questions.
Thank you, Joel. Great presentation. Just to confirm something you said, the footprint of the proposed essentially matches what was there previously.
Chairman Loper, that's correct.
Thank you very much. Any questions of Joel or staff this time by any of the board members? All right, seeing none, I'm going to open the public hearing. Is the applicant or applicant representative present? I show as the applicant Harry Blaker. Okay. I do have a speaker request card I'll get to in a moment. Go ahead, provide your name, please.
Thank you. My name's Harry Blaker, Superior General Contracting. I'd like to thank the board for my first zoning meeting. Thank Mr. Landis for helping us through the process, and then thank my neighbor Jessica Sarkissian Upfront Planning. She's fortunately a neighbor of mine, so when we got to this point after our red line reviews, I reached out to her because this is new for me. So, so my wife and I are in contract with Michelle Gill, who was with me, and her husband Ray, to restore their fire damaged home that they purchased in 2017. I'm a general contractor, but I'm a restoration contractor, so I don't build new homes and I don't do additions. 95% of my work is insurance related, so fires or floods, wind damage. So if anybody suffered a loss, you can understand the as you say, peculiar conditions, the strangeness of the need to restore or rebuild. So they suffered a fire loss in June 5th of last year. I signed a contract with them to restore their home on the 19th and went through the process to restore the home to its pre-loss condition. So, or like, kind, and quality, which is generally the procedure when you have a loss. All of our homeowners insurance cover restoring it to its pre-loss condition, and we always make considerations for homes, or not considerations. We adjust for law and ordinance, which is part of some people's insurance coverage. Some people don't have that, but smoke detectors, egress, and so on. So in this case, we signed a contract. As insureds, Michelle and Ray are underinsured, so that's a condition of us restoring the home in its present location, because they don't have enough insurance to restore it in its present location. So they have typical dwelling coverage. They have some law and ordinance, which is triggered with smoke detectors and I think some egress and a few other things, but their policy isn't enough. So there's a challenge there. I'm sorry, I'm a rambler. So when I sign a contract to restore a home, we measure exactly the home, everything that it was: brick veneer, slump stone arches. I count the ceiling fans, how many blades they have. I count light bulbs, whether they're CFL, whether they're LED, and so on. And that's what we present to the insurance company to approve, because that's what the insurance owes. The home does not get bulldozed. In fact, the foundation for the home still exists there. So soon after we signed a contract on the 14th, I filed for a compliance inspection, which is to get the inspector on site so we can just discuss the nuances of it. And I apologize for not having a PowerPoint because I've never done that before. So I should have, the compliance report is a handwritten report, says home is total loss less the foundation, which still exists. And at the time we knew it was a little too close. It's not perfectly square. It's about 9'4", 9'4", 9'6". It's cantered a little bit. So we moved to the next part. As soon as I got that, I pulled for a demo permit, and then we surgically disassembled the home. No bulldozer, little bobcat, chainsaw, sawzalls, dumpsters, down to the slab, and that's how it sits today. And those photos are in the report. So blah 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 blah. Sorry. So the home's underinsured by approximately $100,000, and with the demolition permit, we moved to drafting with the addition of truss calcs from our truss fabricator, and submitted for a building permit. And the red lines came back with the zoning needed. So that's why I'm here today. So the undue burden, I'm going to sum it up. The undue burden is they lost their home. Ray Gill got injured, saving 2 of their 5 dogs. So they lost a few dogs, which is common, unfortunately, with fires. This is the first job I'd ever done where, look, I'm going to cry. So first job I'd ever done in 25 years that a homeowner actually got hurt. So pretty unique. And they've lost since June of last year, so 8 months, and until we can get it rebuilt. The time with their family, their friends, and their neighbor, Michelle, or Melissa, who's here. So they've lost a lot more than just a home. Plus, a few months after the loss, their insurance company non-renewed them. And I don't know where they went with that, because it's difficult to, the property still has to have insurance because there's a liability. There's essentially a concrete slab with 67 bolts sticking out of the foundation, which is fenced up, and we got a porta potty that nobody's using. So as for the 2 items for the variance, on their street alone, there are 7 other homes built in the same decade that either have the legal non-conforming lot size, essentially but less than 145 feet width. Everything from 120, they have 126. There's a couple of 131s plus or minus. And of those 7, a few of them have less than a 20-foot setback on the side, either side. So, and a few of those 7 have both. So we're asking for the variance so we can move forward to get the plans resubmitted with the new foundation page, which I'll have to get engineered because we don't have a foundation plan other than saw cutting what is there to put new pipes in. So I'm going to have to get it drafted and engineered. So we're probably a month or more away if we go this direction. Well, no matter what direction, well, if we go this direction, it's going to take another month or 2. If we don't get the variance, I have to throw away all the building plans and we start over, and it's going to take another 6 months. So by that point, their coverage for their additional living expense under their insurance policy will run out. So they'll still be paying a mortgage and they'll have to pay rent. So we're looking to get a variance, please, so we can continue on.
Thank you. Are there any questions of the applicant at this time? I have one. Did you have one? Okay. In your estimation, after the fire, what percentage loss was it? Was it a total loss, 50%, less, greater?
So it's a difficult question to answer. If we went by weight, then it would be 50% because the foundation weighs a lot. If we go by the entire acre property, I would say 65, 70%.
It's
Knowing
value.
that 75% is the tipping point. So I haven't done the calculations, but I don't believe it.
Yeah, my next was going to be geared towards you.
So quick clarification, Mr. Chairman. The lot width is legal non-conforming, and that does not go away. And it has nothing to do with the non-conforming use. The use of the property, single-family residential, is not changing. The fact that it's a platted lot at 126 feet is legal non-conforming for eternity.
I guess my question is nothing you can do about it now, but had they not demoed the house, would it have fallen under a non-conforming use where okay.
No.
I'm seeing no's. Okay.
The setback was legal non-conforming, and that went away when the house
was demoed.
Is demoed. But the lot width is a fact in perpetuity.
Okay. All right. Thank you. Any other questions of the applicant? Oh, member Clapp and then member Person.
Mr. Gerard, aren't you asking us to formalize that lot width?
Yeah, I believe the applicant has requested that. It is completely unnecessary.
It's not necessary. Okay. It's okay as it is.
Okay. That was her question. All right. Seeing no other questions, go ahead and step back and hold tight. We may have more. I do have a speaker request card from Melissa Veselovsky.
And Mr. Chairman, real quickly while she's coming up, and I'm sorry to interrupt again.
No, go ahead.
The items that you're memorializing are not for a variance approval of a lot width, but memorializing the legal non-conforming status of 126.
Okay.
And Chairman, while they're discussing that, I just want to let you know that Member Ward had to leave the hearing at 11:11.
Okay. It's a magical number. All right. If you could provide your name for the record, then go ahead with your presentation.
I'm Melissa Veselovsky, and I'm here to support Agenda Item 6, variance for the Gill Living Trust. I'm the neighbor that shares the north wall with the Gills. This summer was devastating for them. I was home when their home burnt to the ground. I was there when Mr. Gill ran out of the burning building with only 2 of their 5 dogs. I brought him water and wrapped my arms around him as the skin on his bare feet sloughed off from burns, and he faced the horrifying reality that his home, his dogs, his life-saving medications, and all of his belongings were gone in a matter of minutes. I held his wife while she sobbed and tried to get in touch with the insurance company. I bought them underwear and shoes and helped them with resources and chased away the countless unscrupulous contractors that showed up with their business cards and the cruel passersby who asked to make an offer on their property before the fire was even out. My family and I have stood beside them every step of the way. It was incredibly heartbreaking to hear that because of the huge housing bubble in Arizona, they ended up being underinsured. It was absurd to think that $350,000 was not enough to rebuild their little house. Although I don't possess anywhere near the education and expertise that you all have, it does seem like the law in this situation is a bit peculiar. The house had already been zoned and approved by the county years ago, despite a large arroyo and such a narrow width across the property, and the house being so close from its neighbor for a couple of decades already. When I wonder about what may have gone on at the county many years ago when it was getting approved, I think about the intent and the purpose of the zoning ordinance. Quote, "The zoning ordinance is designed to promote the public health, peace, safety, comfort, convenience, and general welfare of the residents of Maricopa County, to guide, control, and regulate the future growth and development, to protect the character and stability of residential, business, and industrial areas." When I read that, it is clear to me how it was approved and why I hope you continue to approve the location of their home. The Gills are good neighbors. They are unassuming. They keep their property clean of debris, vermin, and noise. They help others in the neighborhood, and they are good to the people around them. Everything about where they made their home promoted public health, peace, safety, and comfort. I don't know one other property in the neighborhood that is as narrow as theirs or as close to their neighbor as ours. But I couldn't ask for a better neighbor to be this close to us. These good people have had enough trauma and enough mental, physical, and financial devastation. Rebuilding in a different location on the property creates an enormous increase in cost that is unnecessary and is beyond a hardship for them. How much more can one family take? From their neighbor and from someone who was there, please help them literally rise from the ashes and kindly consider granting the variance that they are seeking. It is only asking that the home be on the same footprint. We need more people like the Gills in our neighborhood and in the world. Thank you.
Thank you. And frankly, we all need neighbors like you. Do we have anyone else in the audience who wishes to speak on this matter? All right, seeing none, do we have anybody online?
There's no one online.
No one online? All right, I'm gonna go ahead and close the public hearing. Turn it over to the board for discussion and or a motion. This is in District 2.
Mr. Chairman, just so you know, Member Ward has left the
Right.
hearing.
Member Clapp?
This sounds awful. This fire loss is just a terrible thing that happened to you, and I really feel bad even listening to it. And it would seem to me that the fire did create a peculiar condition on your property, and that you had to build exactly where your house was before. In my opinion, that means that we should be approving your requested variance of the 9-foot setback. And apparently we don't have to approve the 126 feet, and we should approve BA 2024003.
Thank you. We have a motion for approval by Member Clapp. Do we have a second?
I'll second, and I'll make that. Like staff is just doing our job saying these are the requirements and this is how it needs to be set up, but there are always conditions and circumstances that require a different.
Well stated. We have a second by Member Person. Before I call for the question or roll call vote, does it hurt us to memorialize the lot width? That may be something that they might need to be able to show insurance or show a lender or something, rather than having to try to get a confirming letter from you down the road.
There's concerns expressed, but it helps for our reference
To have it in it? Okay.
Okay, then I will add to the motion to memorialize the 126 foot.
Do we have a friendly, friendly amendment? You agree with that? All right. Rosalie, if you could please take roll call.
Member Carden,
Yes.
Member Clapp,
Yes.
Vice Chair Person,
Yes.
Chairman Loper.
Yes.
Chairman, we have a motion for approval by a vote of 4-0.
Thank you. Good luck to you. That concludes our hearing.
Thank you.